English law has been a great export ever since the time of the Victorians. The question is, after Brexit, will it continue to be such a great export, and will the English court and the English judicial system be threatened? In our view, certainly in my view, it will not. And you can look at it in two ways. Whilst many continental legal systems are setting up English-speaking courts in their hometowns and in their own jurisdictions to try and capture some of the market share which the English courts have at the present time, the advantage of the English courts is tradition, but also precedent. You have centuries of precedent on key areas of procedure, key areas of proper law, which can't simply be created overnight by competing systems. Equally, you have a very well-established judicial bench who have grown up with the tradition of mitigating and litigating disputes and understanding what clients want when they bring a case to the English Commercial Court. The English Commercial Court itself is well established, long established, and reacts to market changes. For example, at the present time, it's looking at issues of disclosure, it's looking at ways and means of being more competitive in terms of costs and understanding clients' needs in terms of costs. Equally, there's some perception that it takes a little bit of time to resolve disputes before the Commercial Court in London. However, the statistics show that that isn't necessarily the case, and probably it's just as efficient, if not more efficient, than some of its competing jurisdictions. The other flip side of this is looking at arbitration. Arbitration in London has long established roots. The English Arbitration Act 1996 is well respected and based on the UNCITRAL model law. The LCIA, the London Court of International Arbitration, is celebrating its 125th anniversary, but it's not looking back, it's looking forward. It's seeing ever more disputes referred to it, and equally it's looking to see how it can be more modern in its approach by the use of technology. We see particularly clients looking at and deciding whether to choose between different competing forums. Should a client choose Singapore? Should it choose Paris as its seat? Should it choose Houston? Should it choose New York? But London still remains popular, and we think will remain popular after Brexit, simply because it's got a long-established tradition with a long-established understanding of how disputes can be resolved. So what are the challenges that will remain post-Brexit? Well, fundamentally, it's market perception. Market perception driven by the demand made by foreign governments and international law firms who see a market opportunity to create uncertainty post-Brexit. However, our view is that post-Brexit, the market will continue to remain the same. English judgments will be capable of being enforced, and English arbitration awards will be capable of being enforced as ever under the New York Convention. Will Brexit make a difference? In our view, it won't make a difference.